I call to order this hearing on case number G 2024-03, book challenge involving book title Pet. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Would you please state your name for the records?
Crystal Marule.
Keith Perry.
Thank you.
My name is Keith Perry. I'm the senator of this district.
Ma'am, there's a lot of talking from the crowd. Could we? Okay, thank you. I have some questions for you, but maybe before I start asking them, I would just like maybe your reflections of what's been going on. If you have any thoughts you want to share, and then I'll address some of my questions.
Sure, and I don't know if I could, Your Honor, not knowing the procedures and how they work, make sure on the rules. Would it be all right if so I understand it? How are this proceeding? How was it determined? Who made the policies? Who made the rules for this hearing? How was that formulated?
By the School Board of Alachua County.
The school members did that? Okay. When you have other issues that are related, like if my kid was going to school and there was a pedestrian safety issue in a parking lot, would this be the format that a parent would come to?
Dr. Jackson, I have to object. Senator Perry is here as a witness, not here as an inquisitor.
Well, you don't have to answer my questions.
I'm just suggesting that Dr. Barule's got 21 minutes left to go, and I will object to any questions, anything that you're requesting answers from us. If you'd like to do a public records request, we'll be happy to entertain it.
Can I ask a question on that? Why is it that I'm asking you a question and the attorney for the school board objects?
Because she's here to represent the side for the school board. I'm unbiased.
So you can answer a question if you have the answer or want to. You don't have to. I'm not telling you to answer.
The question I can answer is based on hearing.
Okay.
But otherwise, I would not be able to answer. But a hearing question, as I said.
Okay, but I can ask a question if you don't want to answer it or it's not appropriate. I do have a question for you, though. Why would the attorney for the school board object to me asking a question? Can you just simply say that's not appropriate or I don't want to answer it?
I don't know. I don't have an answer.
Do you have an answer why I can't ask a question?
Sir, you are here as a witness, not as an inquisitor. This is not a court proceeding per se, but if you're a witness, you're here because Dr. Marule believes you have information to provide the hearing officer that will be helpful in determining. And please take this off of my time. Do not take it off of Dr. Marule's time. But you're here as a witness. If this is not a judicial proceeding, but this is not a legislative proceeding either. So if you've got if Dr. Marule has a question for you that relates to the book that we're had an issue for, then you're certainly welcome to answer. But I will be requesting that the school board disregard anything that has to do with your questioning of us about procedure.
Okay, so it's not a judicial hearing. It's not a legislative hearing. What kind of hearing is this, and where are the rules?
It's quasi-judicial. If you would like to, after this hearing, I can present you with the policies of the school board in terms of hearing procedures, which are permitted by statute and by rule.
And you developed these rules?
No, sir. I don't develop the statutes. They're done
hearing,
up in that place where you work.
We developed
Tallahassee.
the hearing, how this is conducted.
The school board develops. Okay,
Well,
let me go ahead and take this off my time. The school board develops policies. The administration develops procedures because they're operational. The school district superintendent has no control over policy. The school board elected members do. No, you can stop it now.
Okay, then I will make a statement, if that's okay, and please, they're going to be rhetorical questions that you do not have to answer, and you can still object if you want to. As someone just watching some of these hearings on TV, as a parent, watching a parent present a case, I was curious as to if this kind of a hearing for a parent to have a concern, if a kid was being bullied in school, would we have an attorney for the school board want to object and counter everything that the parent was bringing up, the parent's concerns? Any other issue, would the school board have an attorney that would bring witnesses and counter things that? are these the standard policies, or is this a specific thing that the school board has said, we are going to take a parent who has an objection to a book and put her through a quasi-judicial hearing, which if the goal is to get to the truth and to the fact of a book that we're looking at, or is the goal of this hearing to prove the parent is wrong? I noticed in her opening statements, she talked about the author and the author's background, which was brought up by the school attorney, which said this is irrelevant. Whoever the author is totally irrelevant. Then she spent over 5 minutes really taking to task Ms. Marule about her issues and things that happened, and almost insinuating that things that happened to one of the witnesses was her doing. I don't understand that. I don't understand if the role of this hearing is to determine if a book is appropriate or not. And by the way, the word banning is an inappropriate and wrong use of our language to say we're banning a book. We have books that are appropriate for certain people. They just had a group that had a big thing on all the banned books. Well, and they're reading the books. If you had books in other countries that were banned, you wouldn't be reading them. They wouldn't be allowed. If these books are banned, they would not be allowed to read them. We're only talking about that. I just find this, I kind of ask myself after watching a couple of these hearings, asking myself, is there any parent watching this proceeding, this quasi-judicial hearing, and saying, wow, I think that makes me feel like I have a concern about, I'm a parent, I have a concern, I think I want to go down here and do this? Or is this quasi-judicial hearing simply to intimidate parents, not to bring their claims or their concerns to the school board and to this hearing? And I can, again, not as a state senator, this has nothing to do with this, as a parent in Alachua County watching these proceedings on TV, I don't think we're going to have many parents involved in any of these proceedings, and I think that's the opposite of what the school board probably wants. Again, I'll ask you a question. Do we want parents involved in the proceedings, or do we want them to be intimidated by an attorney that's being paid to intimidate parents, not paid to investigate the book?
Mr. Perry, to accuse me of intimidating, that's absolutely inappropriate ad hominem attack. Excuse me. You should know better than that. I would object to that.
Let me explain. These proceedings are in lieu of statutes that were set forth by Florida legislators to the school district, and the school district set policy based on the statute.
The laws that were passed by the Florida legislature and have been told by one school district, I think a librarian, that they were not going to abide by these. And of course, if you read Marxist books, you understand why they would say they weren't going to abide by laws instead of going out and changing those. But the laws that we passed did not intend to have it where a parent was put on trial. I can tell you that, and if you read the Florida statutes that we passed, it is not intended. It is intended for a parent to bring forward the issues and concerns, and for the school board. And if I look at the slides, you see what Mrs. Marule did was a very detailed breakdown of the book, whereas the lawyer just said this is not right. And so I think the law that we passed absolutely is not about putting a parent on trial.
Well, Senator, I have to say, as me, I'm just interpreting the policy set forth in procedure by the school board and the superintendent with his procedures for that policy. So in lieu of what we're having here today, if you have a concern, could I suggest that we take it up with the district office rather than here? Because nothing can be changed here at the hearing.
Right. I'm agreeing with you on that. You're in a position where you've been put in to be a mediator in this process, and I understand your role. I don't understand the school board's attorney's role and why, if it's not adversarial, then someone's not watching. But the role of there's nobody going to watch this on TV and watch the exchange that happened today and happened in previous and say, this is an adversarial position that the school board has put the parent in.
Well,
and that is not the intent of the law.
Then you have the respondent. You have the district and you have the citizen that's bringing. So you got both sides that have an opinion to for me to make a recommended
Okay.
order. So we have to have, and that superintendent has is staff attorney, and respondent, Ms. Dr. Barua has her, a friend, a retired lawyer with her. So it's not that we're trying to be adversarial,
But it
we're
is.
trying to balance it.
Well,
Okay.
but it is adversarial, and that question you bring up, why would a parent have to have either an attorney with them?
She doesn't, she just have a witness.
Okay. Why would a parent, why would the school board then have an attorney?
That's a
I get-
question that you're gonna have to ask the superintendent.
And is the superintendent the person, or is it the school board?
Well, school board sets policy.
Mm-hmm.
And from the policy, the superintendent, he implements procedures.
Well, this is what, and I've read this book, and I've looked at her information. I've heard the attorney say that this is not Marxist or the other things. The information that you have is pretty well documented. This book is not appropriate, and if you read the documentation, or you can listen to the generalization by the attorney that says this is appropriate. That's a general statement, whereas the facts bear out, and if we talk just specifically about this book, about the hearing, which again I think is very unfortunate for parents to have to go through this. And by the, there's, I see one parent who's done this. I don't know any other parent in this district that would want to subject themselves to this. And even at the beginning, not to get too off track, but why would her personal information, the very first thing that she did, be released to the media and the press is another adversarial type of a thing. But dealing with this particular book and the laws that we passed, not dealing with the proceedings that are taking place, but you can see the data, you can see the points that took a lot of energy and time to go through this book and point this out. And if you study history and Mao and Marxist, and you understand the structure, the government, the family, laws, you understand revolution, then and if you understand history, then you're going to understand that this book is clearly in the direction of Marxist and revolutionary history, that you do not change laws through elected officials, you change laws through revolution, and that's clear in the book. That's not debatable, and is a book that promotes all kind of other demonic things in a religious cult movement, but it also promotes revolutionists, not law-abiding people who says, we have a system of government that if you want to change things, you elect people, you work hard to get them elected, and then you have them represent you in law. So the book on its face, not on its face, on its face maybe you can interpret it one way, but in detail, in the language of the book, it's clearly by the laws that we passed. Again, you can disagree with the law. You can say the law is bad, but when you start having people say that we're not going to abide by the law, that's a troubling road, and we're all not going to be happy with that direction that we go. So I'd be happy to, I don't know if you had any other specific questions.
Well, thank you. I have a few clarifying questions. Do you expect the district media specialist and the school media specialist who take the training to abide by the criteria in their training to select texts?
Yes.
Is there?
By the law, I'm sorry.
Yeah, so would it be appropriate for a district media specialist to say, I will not consider that slide because I believe it is mistaken when I select books? Would it be appropriate for a district media specialist to say or answer no when asked if they will follow the criteria stipulated on slide 31, which is common selection criteria for instructional materials, library materials, and reading lists? And they say, no, they won't follow those criteria.
For anybody in any authority to disregard any laws, rules, statutes would be inappropriate, and not only inappropriate, but very damaging to have a person in a government position helping educate our children, saying that they will decide what laws they
I'm
will abide
constrained to
by.
object and move to strike. He doesn't have any idea, he is not given a proper hypothetical, and this is inappropriate testimony. We are
It's a
here to
hypothetical
deal
answer.
with, excuse me, sir, we are here to deal with the book Pet. We are not here to deal with the hearing process or the credibility of any of the employees of the district.
Well, then how come you had 5
Excuse me,
minutes?
sir.
How come you had 5 minutes
Excuse me,
to talk
sir.
about
This will
Excuse
come off
me.
of my time. Please add back a minute of her time or a minute and a half of her time. But it is absolutely inappropriate for this gentleman to come in here and try this procedure that we have been doing now for the 6th time. She happens to be the only parent that has objected. Nobody else has taken it this far. But it's absolutely inappropriate for him to denigrate the people of this, the citizens, the employees of the district, based on her hypothetical, which is inappropriate. I'm going to ask the school board to disregard any statements by Mr. Perry, and that's all I'm going to say about that. You
Can I
stop
object to her objection? This is not a hypothetical. This
excuse
is
me.
documented in the record
Dr. Murrow,
from the Melissa
at the
hearing.
closing, you may have your closing statement.
I can't object to,
No, no, we're not
this is
objecting
in
to
the
the.
record.
You,
This is in
we
the
have a
record.
court recorder here, and all of this is, so it's there. So
I
if
know,
you
it's
wanna
there from
have
the
it, put your
hearing, Melissa,
petition
which
in
she
to-
brought up. She brought up,
You can put your petition in to have it struck as well. But it's, at this point, it's not a debate. I'm supposed to be hearing information where I can make a,
but you were here for that hearing. You
Yes.
heard the district media specialist answer, no, she would not use those criteria to select
but
the
the
text on
miss,
slide
I don't
31.
recall that right now. She's not here to be a witness. You're asking me something to
Because
remember.
I'm not allowed to call her as a witness.
I understand.
She can't call her now.
Sir, you're not in this, Mr. Edwards. Now, you're not part of this. You're only there for her support. Okay, please, let's maintain civility. All right. Do you have
Okay, and
another
I have more,
question?
yes, I have more questions.
Okay.
And I'll just, I'll answer, my answer is the same. On a hypothetical, if anybody that is in government that works for the school openly said they were not going to, this is hypothetical, said they are not going to abide by a law or a rule, they should not, that would be wrong.
Thank you for your answer.
What, sir, oftentimes it's been said by the staff attorney that any book that gets a child to read is a good book. In fact, she doubled down again, or tripled, or quadrupled down again on that today. And we've also had the district media specialist say that every book that's on our shelves deserves to stay on our shelves. What do you think of those mindsets for those who are supposed to be evaluating the criteria for book appropriateness?
Just note my objection to this continued line.
Yes, so
That was from today's hearing. She said it in her opening statement.
you're asking for opinion. We're trying to fact find. That's an opinion, Dr. Moreau, from the senator who is not a certified media specialist.
But I am.
Okay, but you're asking him for his opinion.
I'm asking his professional opinion. He was invited as my witness as a professional, and I believe when you've invited your professional opinions, they were allowed to give
You're
their professional
asking him
opinion.
about selection criteria for a book.
He passed this statute. His opinion is relevant, and I'd like to hear it.
The statute is clear. For
would like to
instructional
talk-
and library, they're both different.
I would like to say that we do have a law on the books that says certain books are not appropriate for certain age groups. And that there's a proceeding, and if we said and they believed that there was no criteria, then we would not need to have this hearing, would not need to have any kind of laws in the books. But we do have laws in the books that specifically say there is certain material that is not appropriate for certain age groups. Again, it is not banning anything. What it is saying is that there is certain information that should not be disseminated to certain age groups because it is not appropriate. And to state that that is incorrect, that's an opinion, and anybody can have an opinion, but to state that publicly, to say that any book is appropriate, goes against Florida statute.
Thank you, sir. Also, on slide 38 of the media training, it states, parents that are challenging or objecting to materials should not have to prove that those materials are objectionable. Instead, the individuals that chose the materials must be prepared to defend the educational value of the materials if needs arise. Do you believe that is what is happening here today?
No, I think it is the opposite.
Again, note my objection.
I believe that is the opposite of what is happening here. And as the attorney mentioned, you're the only parent, and now you know why. This is not. You are on trial, and that is unfortunate. And I don't think that is certainly. I know that is not the intention of the Florida statute.
Senator, that's an objection. She's not on trial. We're hearing. We have a hearing going. Do you
I
have
know
any questions?
I know the petitioner is on trial, which is not the way that the law was intended.
Petitioner is only to present her side, to sway an opinion.
But Florida statute does not say she has to present and defend her side. That's the Florida statute. It is the role of the school board to present why it should not be, not for her. That's the way the law is, and that's the way it is in judicial hearings, that you have to do that. So she asked me a question. We'll move on. I know you're running out of time.
Oh,
Yes, sir.
yes,
So I have another question. The district often brings up the fact that a parent can limit their child's access to any specific text by filling out a form. Do you believe that the parental restriction option is intended for books that don't meet the selection criteria? Or let me reword it. These books that obviously are inappropriate and don't meet the criteria, I am being told that I can individually, title by title, limit my child's access to them. And let me add to that. Furthermore, though, when I said, then please tell me all the books that have references to pornography and dirty magazines in the K-5 environment so I can restrict my child's access to them, they say, we're not able to do that level of query. Do you think it's appropriate, instead of deeming a book inappropriate, which it absolutely is, to say to the parent they need to find each inappropriate book and individually ban their child from having access to it?
Yeah, that is an impossible task to make a parent go through. And you had mentioned, and the attorney mentioned too, that there are websites that bring this out, and you would think that the school would use that website as a tool to do investigating, not to abide by it, but to use it as a tool to say, hey, they're doing our job for us to follow Florida statutes. It would be a great opportunity for them, but it is impossible to think that parents are going to be able to go through entire media libraries and instructional books and determine that. That would be an impossible task and would not be appropriate to put parents through that.
Do you think it would be an appropriate task for the staff to proactively seek and remove books that don't meet state criteria from the school library?
Absolutely, and they should be doing that according to Florida statutes. And they should be doing that for the parents.
And how would you expect professionalism to be demonstrated by staff when a faculty member, other staff, or parent identifies a book that may not meet criteria?
I'm sorry, repeat that?
What would you expect their professional demeanor to be like when a parent raises concern or a teacher raises concern about a text that may not meet the criteria? Should it be antagonistic, or should they be collaborative and grateful for them
Dr. Miro.
having that information brought to them?
No, Dr. Miro. That is an opinion you're asking for. We're trying to find fact on this.
I'm not quite sure how to word this appropriately because I'm not a lawyer. But my question is, how should the collaboration be between the school and a parent when a parent detects a questionable text? What should the professional response of the school be?
Professional response would be that of making sure that the parents' needs and the child's needs are taken care of, and that that the Florida statutes are followed. And so I would hope it would be and these are opinions, and I apologize, but you often hear about schools wanting parents to be involved in the process, and I think this process discourages parents from being involved in the process.
Dr. Miro,
Does the statute?
this is the fact-finding process here. You filled it out. We are following all the procedures that are outlined on the front page, which you're well aware of. Senator Perry does not have to give his opinion. It's here. The school board procedure was set by the superintendent. So let's ask questions on PET, please, so we can move forward. You have 4 minutes left for your
Well,
closing.
my question is that when I initially raised my concern, it was sent to the media and I was doxxed. Then the district colluded with activists to publish clips about me on Twitter to defame my character. Then they used family relationships and friend relationships to get a meeting with me to report back to the district. That has been the behavior of the district to a parent who
Miro,
raised
that is
objections.
that's not in my domain. I have
But I'm
nothing-
asking the senator, my witness, his professional opinion if the statute had taken into consideration that
But
should be
that
the
is
appropriate
not why
reaction of a
we're
school
here,
district.
Dr. Moreau, we're here for PET. The professional opinion for Senator Perry is about the novel PET.
Right.
We have 3
Sir,
minutes and 47 seconds for you to have your closing.
Sir, I would give you my time if you'd like to say anything else. If not, I do have a brief closing statement.
I would just, again, I started out with this whole process. I think the process is designed to intimidate parents and keep them out of the process, and that's the exact opposite of not only the statute, but it should be opposite of what the school board wants, which is wants parental involvement in this, not to intimidate. And there is nobody There's nobody watching this, and people can agree or disagree on the book, but there's nobody watching this that doesn't say, there's no way, as a parent, I'm going to go through this process. And I think that's a very unfortunate thing. That's not you, but that's them. That's a school board and these policies and this quasi-judicial thing that a parent has to go through. I think it's very unfortunate for parents to go through.
Thank you, sir.
Attorney Seeger, do you have any question?
When we did away with witnesses, it was that she could present a witness. But we're about no cross-examination. So I have nothing to say other than I've already made my objections. So
Thank you,
he can be excused.